Distinguished guests, speaker, and fellow participants, good evening to you all. As we are about to commence our session, I kindly request everyone to settle in and ensure your connection is stable. Before we begin, I would like to remind all of the participants the ground rules for today's discussions. First, be punctual. Please join the meeting on time and ensure you remain connected during the session. Second, dress appropriately. Even though it's an online meeting, participants are encouraged to dress appropriately, maintaining a professional appearance throughout the sessions. Third, minimize distractions. Please find a quiet, well-lit space for the meeting and minimize background noise and distractions. Mute notifications on your devices to avoid interruptions. Fourth, participate actively. We invite an active participation. Please engage in the discussion, contribute your ideas, and listen attentively to others. Should you wish to contribute or pose a question, please utilize the raise hand feature or submit your inquiries through the chat box. Fifth, respect others' speaking time. To maintain order, please refrain from interrupting any speaker. All questions will be addressed during the designated Q&A session. 6. Use neutral language and tone. Please maintain a neutral demeanor in your language and tone and avoid using slang or inappropriate language. 7th, be mindful of camera etiquette. Keep your camera on unless there is a valid reason to turn it off. Maintain proper posture and avoid distracting movement or gestures. Furthermore, to maintain our administrative records, the link for the attendance form will be posted in the chat box shortly. We encourage all participants to complete the form to ensure your presence is officially documented. Alright, without any further ado, Om Swastiastu, Assalamualaikum warahmatullahi wabarakatuh, Shalom, Namo Buddhaya, may peace be upon us. I am thrilled to welcome all of you to our monthly discussions on global legal affairs. This event is brought to you by Udayana Research Center for International Law and the Student Community for International Law from the Faculty of Law at Udayana University. I am Pasha, and I'll be your MC for today's sessions. Before we proceed, let us extend our deepest gratitude and warm welcome to our distinguished guests who have graced us with their presence. First, to Dr. Imade Budi Arsike, SHLLM, as the head of the International Law Department. And second, to our esteemed facilitator, Dr. Cokorda Istridiah Widiantari Pratnya Dewi, SHMH. We are here to discuss an issue of international law today with the title, The Future of Maritime Boundaries in the Age of Climate Change, Fixed Baselines, the ICJ Advisory Opinion, and Indonesia's Territorial Jurisdiction. As we know, the climate crisis is no longer merely an environmental concern. It is fundamentally reshaping the legal geography of our world. As rising sea levels continue to transform coastlines, an important question emerges. Should maritime boundaries evolve with nature, or should they remain fixed to preserve sovereignty, legal certainty, and the livelihoods of millions? Following the International Court of Justice advisory opinion on the climate change issued on 23rd of July 2025, this issue has become one of the most significant debates in contemporary international law. For Indonesia, as the world's largest archipelagic state, the discussion extends beyond legal doctrine. It concerns the future of our territorial integrity, maritime governance, resource security, and national resilience. Before we move further, with today's event, I would like to call upon Dr. Imade Budi Arsika, SHLLM, to deliver his opening address. The time and place is yours.
Hello, Pasha. Can you hear my voice?
Yes, you're audible.
Thank you very much. So first of all, I would like to express my gratitude to Professor Igusti Ngurah Parikesit Widiateja, PhD, as the initiator and then the founder of Udana Research Center for International Law and Policy, the UNCIL. It is a prestigious research group at the Faculty of Law, Udayana University. Also, I would like to greet my colleague, Dr. Cokorde Istridia Widantari Dewi. Yeah, you will become the facilitator again. Yeah, for the UNCIL session. Thank you very much, Ibu Cok. Yeah. And then there is perhaps professor and lecturer of International Department of the Faculty of Law, Udayana University, which attend and perhaps maybe will join later. Also, Ana Agung Safitra Beauty Anaya, the president of the Student Committee of International Law, the ACIL, and her executive board member. Miss Lai Titya Arista, so we usually call Leah. How are you today, Leah? Okay, you will be acted today as a resource person, as a speaker. And allow me to inform you that I was assigned by Dr. Made Suksma Prijani Devi Salain. She is the coordinator of Bachelor of Law study program at the Udayana University Law School. So she assigned me to deliver an opening remarks on these academic occasions. I'm so proud because we organize again the UNCIL event, so the International Law Today, the monthly discussions on global legal affairs. It is a co-curricular programs which is jointly organized by International Law Department of the Udayana University Law School and the SCIL. So I think I would like to reiterate, perhaps there are several new participants. So I would like to inform you that the UNCIL since last year initiated this program under the initiative by the Professor Parikesit. So this event presented the most talented students who conducted, let's say, a Bachelor of Law research on the issue of the international law. So we invited them to disseminate their knowledge and research results. It is why in the International Law Department, we can update any recent issues in the context of the international law. In particular, the topic today. So the topic today about the future of maritime boundaries in the age of climate change, fixed baselines, the International Court of Justice advisory opinion, and the Indonesia territorial jurisdictions. I mean, this topic discusses the basic concept of public international law. So one is about the state jurisdictions, and then also if we talk about maritime boundaries, little bit there is issue of the law of the sea, and then the climate change. This is part also of the topic which is generally discussed in the international environmental law, and of course there is the little bit issue of the Indonesia's foreign policy. How about the national interest of Indonesia? So, I mean, there will be a combinations of several concepts and also branches of public international law in this event. I mean, in today. Therefore, I would like to express my high appreciations to Laetitia Arista, Leah, which because you would like to become the resource persons as the speaker of this event. And for the participants, I would like to admit and also support that Leah was the president of the Student Committee for International Law. and she joined several international book court competitions. Yeah, represents the Faculty of Law Udayana University in Washington D.C. and also in Japan. Yeah, so I mean, we are very proud of her, and we admit her contributive effort to support the international law department at the Udayana University Law School. Congrats for Leah, because you already finished your research on your Bachelor of Law thesis. So thank you for all committee to preparing this event. And finally, on behalf of the Bachelor of Law Study Program Coordinator, allow me to declare that the co-curricular program of the International Law today, monthly discussions on global legal affairs on the topic, the future maritime boundaries in the age of climate change, fixed baselines, the ICJ advisory opinion, and Indonesia's territorial jurisdictions is open. Thank you very much. Pasa, please.
Thank you very much to Mr. Budi Arsika for the wonderful remarks. And the moment you have all been waiting for. All distinguished participants, I'm excited to introduce our speaker, Ms. Leticia Arista SH, a graduate of Faculty of Law, Udayana University. Her research focused on public international law, particularly the law of the sea, climate change law, and the evolving legal challenge surrounding maritime boundaries. She has a strong interest in examining how international legal development shapes state sovereignty, maritime governance, and the protection of coastal and archipelagic nations in the face of climate change. Also, to help us navigate our discussions, please welcome our facilitator, Dr. Cokorda Istridia Widiantari Pratnyadewi SHMH. To Ibu Codia, the time is yours.
Okay, thank you very much for the MC, Pasha. Thank you very much. So before we start, let me give my very warm greetings to all of distinguished guests and all participants. Om Swastiastu, Assalamualaikum warahmatullahi wabarakatuh, Shalom, Namo Buddhaya, Salam Sejahtera, dan Salam Kebajikan untuk kita semua. Good evening, the Honorable Head of Bachelor of Law Program. On this occasion, for Honorable Head of International Law Department, Bapak Dr. Imade Budi Arsika SHLLM, and of course the founder of Udayana Research Center for International Law, Bapak Profesor Parikesit Widyateja SH Hum LLM PhD, and of course for President SYL and all the committee who prepared this, and all participants, and the distinguished guests, maybe any other professor and lecturer from international department or from guests in other university. Thank you for joining us this evening. Okay, climate change is reshaping not only our environment, but also the legal framework governing maritime boundaries. Today, we will discuss its implications for fixed baselines, the ICJ advisory opinion, and Indonesia's territorial jurisdictions. This topic has become increasingly important as climate change and sea level rise pose significant challenge to the existing legal framework governing maritime boundaries. These developments raise fundamental questions about the stability of coastal states, maritime entitlement, and adequacy of international law in addressing emerging environmental realities. In this presentation, the speaker will explain the concept of fixed baselines, examine the significance of the ICJ advisory opinion, and discuss their implications for Indonesia as the world's largest archipelagic state. So, Leticia Ariesta, SH, recently graduated from Universitas Udayana with a GPA of 393. She served as the president of the students SEAL for international. She served for president SEAL for 2025 term. She's active. She also actively involved in various legal research projects and academic publications. In addition, she has represented the Faculty of Law Udayana University as well as Indonesia in several prestigious international moot court competitions, including the Asia Cup 2025 and Philip J. Jessup International Law Moot Court Competition 2025. And like what Pak Budi said before, we are so proud of Leah. Thank you, Leah. And now, without taking any more of your time, I would like to invite Leah to deliver today's presentation. Please take your time.
All right, thank you so much for Bucho, Pak Budi, and Prof. Sigit for opening the session today. I would like to also state my thank you and gratitude for UNCIL, the Udayana Research Center for International Law, and also for Student Committee for International Law for facilitating and making today happen. Before I start, I'm going to share the PowerPoint. Is it visible for everyone?
Yes.
Yeah.
All right. First of all, Om Swastiastu, Assalamualaikum warahmatullahi wabarakatuh, Shalom Nama Budaya, and may peace be upon us. First of all, I would like to reintroduce myself. My name is Leticia Arista, and anyone here can call me Leah. And also, just a little bit of a note. If anyone have a question, I think you guys can just put it on the chat and we'll read it and I'll answer it at the end of the session so that the Q&A session could be done more efficiently. Also, okay, so right on to the next slide. So here, this is basically the main point, the main focal point of my research, which is the paragraph, which is the paragraph 362 of the obligations of states in respect of climate change advisory opinion that were adopted by the International Court of Justice in 2025. Perhaps also a little bit of a background other than this paragraph itself, actually why I've started to research more deeply on this material is because this is the main topic of JESUP 2025, in which me and my team competed on. And at that time, the topic of fixed baseline was brought upon on the mood problem. And at that time, the climate change advisory opinion was not yet adopted. So on my competition days, it was more vague, it was more ambiguous, but today, there's already the climate change advisory opinion, which on the paragraph 362, it stated explicitly, in which I bolded, state parties to UNCLOS are under no obligation to update such charts or lists of geographical coordinates. this paragraph actually caused a big havoc on the participants of JESUP all around the world because this basically overrides our argument, right? Because at that time, the concept of fixed baseline was arguable, but because of this advisory opinion, then the fixed baseline concept is already deemed quote unquote valid under international law. So let's get into what is fixed baseline itself. So fixed baseline is a concept on the law of the sea, a new concept in which it may be enforced by a state to freeze its baseline at a certain point and at a certain time. This concept may be adopted by state by adopting legislation or declaring such measure, or by simply if the state does not update their published charts containing the coordinates of its baseline. So here there's a picture in which I drew it myself. This is just like some kind of illustration on how does fixed baseline works in terms of the determination of a baseline itself. Perhaps understanding what baseline is in itself, a baseline is the line to which it may be drawn on the coastline of a state to determine the territorial zones of a state. So it is very detrimental to the determination of, let's say, territorial sea, and then contiguous zone, EEZ, and also continental shelf. Here, the illustration only consists of EEZ. So when, if my cursor can be seen, sorry, just checking. I think it can be seen, yeah. Okay, so here is the fixed baseline. The red line shows the fixed baseline. Let's say if a state has adopted a fixed baseline on 2015, while on 2016, the actual coastline has receded because of sea level rise, then according to fixed baseline, the EEZ line would be further towards the sea. While if according by the actual coastline of a state that has receded, the EEZ would be much closer to the land. And this is why fixed baseline was debated by the academics of international law at the time prior to the advisory opinion. So the actual coastline that is marked by the green lines here is showing the concept of ambulatory baseline, which refers to the understanding that the determination of baseline shall move accordingly with the geographical changes on the coastline. If a state has adopted such fixed baseline, then they may enforce and they may deem the fixed baseline which does not reflect the actual coastline as their baseline. And thus, the territorial zones of such state will not refer to the actual geography anymore. Now moving on to the next part. Even though there has been an advisory opinion in which I've cited on the paragraph 362 before, which shows how the International Court of Justice has accepted and recognized fixed baseline, the concept of fixed baseline as legal and valid under international law. However, it shall be noted that advisory opinion is in itself non-legally binding. However, advisory opinion carries great legal weight and moral authority. So, on the advisory opinion, although it has been clearly stated that states have no obligation to update their charts containing the baselines, it can still be argued whether such advisory opinion has reflected the actual practice of international and the actual rule of international law or not. And a little bit of understanding of an advisory opinion, since I've noted that probably not all of the participants here are very deep into international law. So advisory opinion is another form of documents that may be adopted by ICJ, in which while there are contentious procedures such as cases between states, advisory procedure is different, in which why it is non-legally binding, because it is only a document where the ICJ clarifies and answers the legal questions from UN organs and specialized agencies. So hence why on the next part, I will try to check the legality and the validity of fixed baseline under the framework of the sources of international law. If you guys are aware, on Article 36(1) of the, Article 38, paragraph 1, of the International Court of Justice stated, there are several sources of international law, namely international agreements, in which here UNCLOS, and then customary international law, and also the general principles of international law. There is also a secondary source, namely the decisions of courts and also judicial teachings of highly qualified publicists. However, this analysis will only depend on the primary sources of international law, namely those three. First of all, onto the international agreement. On UNCLOS, there are no explicit article in regards to fixed or ambulatory baseline, and this is exactly why the concept itself is very highly argued and debated in international law prior to the advisory opinion. What can we see on UNCLOS regarding baseline is only on the three types of it. First, normal baseline on Article 5, straight baseline on Article 7, and also archipelagic baselines under Article 47. Thus, if we were to analyze the validity of fixed baseline, we may refer to the framework of the Vienna Convention on the Law of Treaties, where there are several ways on how we may interpret a treaty. First, on Article 31 on the VCLT, and you guys may also notice, especially if you guys are taking the Matkul Perjanjian Hukum Internasional, it is very useful for you guys to understand the concept of how we may interpret an international agreement. So on Article 31 of VCLT, the general interpretation of the treaty must be in accordance with the words in itself, but in the context of the object and purpose of such treaties. So on Article 5, regarding normal baseline, it is stated that the normal baseline for measuring the breadth of the territorial sea is the low water line along the coast as marked on large-scale charts officially recognized by the coastal state. Here, on Article 5, there are two elements that are being considered in the determination of normal baseline. First is the low water line along the coast, which shows the geographical consideration. And then second, marked on large-scale charts officially recognized by the coastal state, which is the administrative consideration. However, on the application of fixed baseline, there would be a possibility where two of these elements would contradict each other. Let's say, if the normal baseline that is marked on the large-scale charts is contradictory to the low water line along the coast, the actual coastline and geographical reality of it, this raises a question whether fixed baseline would be in accordance with international law, especially on Article 5 or not. However, on to the next part, on Article 7, paragraph 2, regarding straight baseline, there is this clause where it is stated that on straight baseline, notwithstanding subsequent regression of the low water line, the straight baseline shall remain effective until changed by the coastal state. This is a concept of fictitious stability that was referred to by several international scholars, and it is arguably the same with fixed baseline, as straight baseline and fixed baseline both propose a fictitious stability on a state's coastline in the face of changes, in the face of geographical changes, namely on paragraph 7, on Article 7, paragraph 2, the consideration is the presence of a delta and other natural conditions of the coastline. If it is highly unstable, then such fictitious stability may be applied. However, on fixed baseline, the consideration that is relevant to the application of fixed baseline is if the sea level rise caused by climate change has caused regression on the coastline, thus fixed baseline might be applied by the state. However, then, other than Article 5 and Article 7, Paragraph 2, there are also Article 7, Paragraph 3, and also Article 47, Paragraph 3, which is very similar with each other. The first one is in relation to the strait baselines, and the second one is in relation to archipelagic baselines, in which both of these articles stated that the determination of such baseline must not depart to any appreciable extent from the general direction of the coast, same as this one, and it must be sufficiently closely linked to the land domain. This has shown once again the doubt that legal scholars have onto the application and the validity of fixed baseline if we refer to UNCLOS. However, again, if we go back to the VCLT framework in relation to interpretation, the subsequent Article 32, following Article 31, has provided a supplementary means of interpretation, where in this method of interpretation, the court or anyone in terms of research of international law may refer to the subsequent practice of the parties to the international agreement. This is a very similar concept with the determination of customary international law. So, in customary international law, a rule may be deemed as custom if it has fulfilled two requirements. First is state practice, and second is opinio juris. Basically, just a little bit of background on why these two elements arises in the determination of a custom. It goes back to the North Sea continental shelf case, where it is the first time the court has ever put a very explicit elements on the determination of custom. And in that case, it is also a case about the law of the sea, because at that time, UNCLOS has not yet been adopted, and hence why the law of the sea at that time refers solely on the customary international law. So on the state practice and opinio juris, state practice is basically state practice as the name shows. However, on opinio juris is basically the mens rea. It is the intent. It is the subjective element of a state, whether they have practiced such rule or not, whether the rule is recognized as a rule that is binding upon states. So here to prove state practice and opinio juris, and also again in relation to Article 32 on the supplementary means of interpretation, which we may refer to the subsequent practices of states in relation to the performance of such international agreements, there are a few categories that we may refer here. There is declarations, firstly, from Pacific Island Forum, Alliance of Small Island States, Climate Vulnerable Forum, and also the Organization of African, Caribbean, and Pacific States around 2021 until 2022, in which the states of those state international organizations has clearly supported the concept of fixed baseline. Within these declarations, the parties stated that they agree that state parties to UNCLOS does not have any obligations to update their baselines that have been published. So that's first on how the declarations have shown how state practice and opinio juris on the performance of fixed baseline has been fulfilled. And secondly, onto the legislations, as noted previously, fixed baseline itself may be applied, may be exercised by states by first adopting legislations. So there are several explicit legislations that have shown how states have adopted such method of fixed baseline. First, Maldives on 1969, then Marshall Islands on 2016, Tuvalu on 2012, and also Kiribati on 2014. Also, one other bonus I've added here is actually PP nomor 38 tahun 2002 tentang daftar koordinat geografis titik-titik garis pangkal kepulauan Indonesia, which has been amended by PP nomor 37 tahun 2008. Why did I add this bonus in which it is Indonesia's legislation on its baseline? The thing is, fixed baseline itself, its application in itself is ambiguous because, as stated before, states may exercise its baseline by simply not updating their already published baselines, right? So if Indonesia has already adopted such legislations, setting out their baselines, if Indonesia decided and explicitly stated or declared that they have no intention to update these baselines, hence automatically Indonesia would have clearly adopted fixed baseline also. So on to the next one. It is the positions of a state in relation to the adoption of fixed baseline. These positions are taken around 2020 to 2022, so it is before the adoption of advisory opinion of climate change by the ICJ. And these positions are shown by the states in their submissions to the ILC group of study on sea level rise, in which one of the discussion is whether the states of UN accepted or recognize the legality of fixed baseline under international law. So first, New Zealand and Cook Island and also Antigua Barbuda has clearly stated that they have no intention to update their published baselines. Secondly, those states who doesn't practice or maybe not practicing fixed baseline but explicitly supporting are the majority of the states around the world. So why I say it maybe, well, yet again, most states have already adopted, most states in the world actually has published most states in the world have actually published their designated coordinates for their baselines. And thus, many states in the world may or may not have realized that they have practiced fixed baseline since a long time ago. So fixed baseline is actually quite an ambiguous concept in itself because it is merely some kind of validation for a state whether they have acted in accordance with international law or not. So here, other than the majority of the states, this includes Indonesia. On their submission to ILC's group of study on sea level rise on 2022, Indonesia has also shown a clear support for the concept of fixed baseline, in which they stated that such rule of international law, if recognized by the international community, fixed baseline may enhance states' sovereignty over their natural resources. That will be further elaborated later because we will also talk about principles of international that relates to the fixed baseline. However, moving on, other than the majority of the states who explicitly supports the concept of fixed baseline, there are also some states at that time who were unsure or neutral about the validity of fixed baseline, namely Germany, China, Colombia, and China. These states clearly supported their application of ambulatory baseline in contradictory with the fixed baseline method. And these states chosen the positions in which they are neutral and such as Germany, the state in their submission stated that the concept of fixed baseline cannot yet be deemed or absolutely considered as a customary international law, as they would like to see how this goes for the future. Well, then on 2025, the ICJ thus indeed put out an advisory opinion in which it stated that fixed baseline is valid on international law. So a bit of a intermezzo before we move on. So this is um a picture of the minister of Tuvalu, in which at that time this person declared and like declared a video where it stated that as Tuvalu at that time and until now is on the brink of territorial loss because they are very small island states and the sea level rise is very has a very imminent danger toward Tuvalu, and hence why he, at this picture, stated to the world that, hey, maybe the international community should see how sea level rise has created a very big impact to states like us, and hence why we should try to see how fixed baseline might be recognized in international law for the sake of states like us. So that a bit of intermezzo. But moving on, here are also the principles that would be relating to the application of fixed baseline. So on international law of the sea, there are two prominent principles that are very often cited again and again on any cases of the law of the sea, and especially in maritime delimitation, in which first, permanent sovereignty over natural resources, and second, the land dominates the sea. What are these principles? So, permanent sovereignty over natural resources is, as the name shows, it is the concept of state sovereignty, kedaulatan, which other than states having sovereignty over their territory, states also have sovereignty, a permanent one, over the natural resources under their territory. So this principle was first brought upon, or maybe first explicitly endorsed by the United Nations General Assembly, and it became a very prominent principle in which this principle would support the application of fixed baseline because if state applies such fixed baseline, then they would have better certainty in terms of their sovereignty over the natural resources on their sea, on their ocean, on their territorial sea, and also on their EEZ, and also other than that on their continental shelf. On the other hand, there's also the principle of the land dominates the sea. So this principle this principle was introduced and also recognized by international law far longer before the permanent sovereignty over natural resources. So the land dominates the sea is basically the principle on how state may determine their territorial zones. The meaning of the land dominates the sea, meaning that the territorial sea of a state and any territorial zone such as EEZ and continental shelf must be determined in accordance with the land, and hence why baseline becomes the line that would then determine the territorial sea and other territorial zones of a state. This principle in itself, in hindsight, shows how there is a contradictory principles to the determination of fixed baseline because as has been explained before, if a state applies fixed baseline, then the determination of their territorial zone would not be in accordance with the physical geography and the physical reality at that time anymore, but on the juridical determination of a state, namely the geographical coordinates of the baseline that they have published. Well, the question here would be which one wins then in terms of the contradictory principles in this case. It is very, even at this point of my research, the thing about international law is that it is very, if you guys have learned on the very first matkul of international law on Hukum Internasional, the first thing that you will be introduced to is the fact that international law is coordinative in nature. There is no um, there is no one absolute standards for international at all, and hence why in international law a lot of things are highly debatable, and hence why if the participants here are still considering to choose their concentration for um, semester 4 ke atas, you guys may choose international law. It is a very fun one because you guys can just like really explore on the possibilities of law. Back to the topic. Land dominates the sea, although in hindsight, again, it is kind of contradictory to the concept of fixed baseline. The International Law Commission, on its report on sea level rise around 2022, 2022, has also discussed about this, and they've stated that the land dominates the sea in current era is more flexible because if we look upon Article 7, Paragraph 2, wait, let's see, Paragraph 7, Paragraph 2. Okay, Article 7, Paragraph 2 of UNCLOS again shows that there is already a possibility and there is already a precedent where such fictitious stability may be enforced by a state where the determination of their baseline might not really be in accordance with the physical reality of a state because other than the land dominates the sea concept in itself, there are other various considerations that might override such principle. And so, the most simple answer to which one wins in these principles would be the permanent sovereignty over natural resources. Because, well, generally, sovereignty is the highest, it is the peremptory norms, where sovereignty itself is, what do I say? Sovereignty is a concept, is a rule, the highest rule of international law, and states have the highest sovereignty. And thus, here, the permanent sovereignty over natural resources, which support that fixed baseline would quote unquote win. Moving on. So, previously, we have seen how the fixed baseline itself may be considered as an acceptable rule under international law. However, as much as it is acceptable, there are also several classifications on rules. Although there are no international agreements that specifically classified these rules, these classifications are inferred from the many types of rules that are already recognized in international law, and there are three classifications. First is permissive rule, where a practice may be permitted, but not all states must act in accordance with this rule. Second is prohibitive rule, where a practice is totally prohibited. No states may act like that, right? And there is a prescriptive rule, where a practice is obliged. So all states must comply to such rule and they must act upon it. So a little bit of example for each of the rules. Prescriptive rule, we would say human rights. All states are obliged to protect and respect the human rights of the nationals in their territory, in their jurisdictions. And that is the example of prescriptive rule because all states are obliged to do so. On the other hand, prohibitive rule, the example we may see it as, let's say, the prohibition against genocide and also the prohibition against act of aggression, crimes against humanity, and many other more where, as defined, as that practice is prohibited, no states are permitted to, of course, conduct such actions as genocide, crimes against humanity, and other else. On the other hand, permissive rule, as the explanation goes, when a practice is permitted, this would be the classification of fixed baseline. So if we look upon the types of baselines that has been recognized under UNCLOS, namely normal baseline, straight baseline, and archipelagic baselines, the first and the most easiest one to point out is archipelagic baseline. Archipelagic baseline is a method of baseline determination that may be permitted to be used by archipelagic states. While for those non-archipelagic states, of course, they don't have to um, apply such archipelagic baselines. The same as fixed baseline. In the observation of ILC and also on several discussions of legal scholars such as Kate Purcell. Kate Purcell is one of the prominent legal scholar uh, uh, that is in favor of the application of fixed baseline, and she stated that fixed baseline should be considered as a valid and legal international rule because it is more of a right of a state to do so, not an obligation. And hence why, even in terms of the determination of state practice, it's okay if not all of the states in the world exercise fixed baseline. But what matters is that for those states who are in need of such rule, they have conducted so. So we can see how Tuvalu, Kiribati, and other small island states and also archipelagic states have practiced such rule of fixed baseline because they are in need of such rule because they are the most impacted states, or we can say specially affected state. I might not go very further into that concept. However, you guys may search on what is specially affected state in relation to the determination of a customary international law, where it is a concept where not all states have to perform such rule for such rule to be considered as customary international law. Because again, in terms of such permissive rule to be considered as a valid rule under international law, what matters is that the relevant states, the most affected states, are actually practicing those. So yeah, fixed baseline, in conclusion, is a rule of international law of the sea that is classified as a permissive rule. Okay, so this is kind of the last part of the presentation that I'll do today. Other than the fact that fixed baseline has been recognized by international law, there are still some downsides to it, some negative impact that the recognition of fixed baseline caused upon the international law community and international law itself. Mainly, it is because the fragmentations caused by the emergence of fixed baseline as an accepted rule on the law of the sea. So there are three categorization or like 3 points on why there are fragmentations that is caused by fixed baseline rule. First, there are conflicts with preceding cases. There are many more, but what I written here is only two, the prominent ones. First is the maritime delimitation in the Black Sea, which is cited over and over again on the subsequent cases, and also maritime boundary arbitration in the Bay of Bengal on 2014. So in these two cases, well, firstly, on the Black Sea case, it is stated that in the determination of base points for the purpose of maritime delimitations, the court and the states must refer to the physical reality of the coastline of the state. And this precedent would be, of course, in contradictory with the fixed basin concept. However, the fixed basin concept itself, however, there will be a question on, okay, but in that case, are there any considerations of climate change? Because fixed basin is specifically arised because of the issue of climate change. However, this is when the 2014 case arises. So in this case, it was between Bangladesh and India, and Bangladesh at that time argued that because of climate change, their coastline is very prone to changes in the future, and hence why India and the court should concede to the argumentation on how the maritime delimitation between Bangladesh and India should be in accordance with Bangladesh's submission. However, the court clearly stated also at that time that in terms of maritime delimitation, climate change considerations are, how to say it, are irrelevant, basically. That was like what the court said. And again, this shows how climate change itself, as the precedent shows, is totally irrelevant to the matters of maritime delimitation. In relation with this, then we will come to the second point, which is the redundancy in the face of court. If the states, most states, or even all states in the world applies fixed baseline as their method of determination of baselines, then there would be a possibility where the rule is just redundant in the face of court. So back again in the Black Sea case, and also again cited in many other following cases, the court, be it UNCLOS, ICJ, or UNCLOS, ICJ, or any arbitrations that are settling the disputes regarding law of the sea and specifically maritime delimitations, they may establish its own base points for the purpose of the settlement of disputes. And this established base points are again in accordance with the physical reality at the time of the dispute. This is regardless of the parties' published coordinates. So hypothetically, if let's say Indonesia has used fixed basin and it has over and over again referred to the PP regarding garis koordinat garis pangkal, if let's say Timor-Leste were to apply a dispute to the court regarding a maritime delimitation with Indonesia, then the already determined fixed basin wouldn't matter, because at that time the court will then determine and establish their own base points to delimit for the maritime delimitation between Indonesia and Timor-Leste. And other than that, there is also a possibility of judicial refashioning of geography. So judicial refashioning of geography is a concept in the law of the sea, in which it is stated in few cases and also in several separate and dissenting opinions of judges in ICJ and also UNCLOS, that no states nor the court may exercise unwarranted distortion of the relevant geographical conditions, even if such distortion is to achieve a result that is deemed equitable. Equitable means adil, basically, in Indonesia. So the question would be, if fixed baseline were to be recognized as a valid rule on international law, would this be deemed as a judicial refashioning of geography? And if so, then the concept of fixed basin itself would be considered as a blatant violation of international law. However, again, as the advisory opinion of the ICJ has stated so, and there are no cases of international law on the court that settles dispute about the usage of fixed baseline, thus this is still an open question for the future development of international law. And so that's all actually. The last one is just then what's next? The question of what's next would be 2 points. First for international law and second for Indonesia, of course. So first for international law, as can be seen that there are fragmentations that surrounds the validity of fixed baseline. It shows how, because there are issues of climate change, it has caused some like chaos in international law. And this is based on the chaotic law theory, which I brought upon in my thesis, where chaotic law theory is basically when there are certain disruption on the situation surrounding the law. Sometimes an immediate change is needed and it caused some kind of butterfly effect to the other following and subsequent and relevant laws, which it became a chaotic law. So Well, the thing is, climate change is definitely a prevalent issue, and there are a lot of international law matters surrounding climate change, which mandates international law to kind of move fastly to adapt to the conditions, and hence why there are certain fragmentations in international law, and that is totally normal in international law. However, then what's next for the international community is to urgently address those fragmentations, because if um, the international community relies merely on the advisory opinion of the ICJ for their applications of fixed baseline, then there would still be certain contradictions with UNCLOS that are questionable. Perhaps the most concrete mm, the most concrete solution for this is actually the amendment of UNCLOS itself. Um, yeah, the amendment of UNCLOS itself, though it is very of an idealistic view, because by the history, UNCLOS itself, in its adoption, it takes like around 10 years until the United Nations states are able to agree upon UNCLOS. So it will be a very long way. However, again, it will be uh, in accordance with how international develops, as it is a very progressive form of law in general. And the second one is, again, what about Indonesia? So basically, as stated before, there are certain indications that Indonesia is actually already um, has already exercised the fixed baseline, with the fact that they have adopted a certain legislation um, that sets out the geographical coordinates of the baselines. So if Indonesia were to decide that they want to explicitly and clearly adopt such method of determination of baseline through fixed baseline, then what Indonesia needs to do is basically to just declare that Indonesia, in this regard, would have no intention to update their baseline in the further time. And Indonesia would then, in the future, diplomatic relations in relation to the law of the sea and the territorial sea, and in the maritime delimitation would refer to the fixed baseline that are already delineated in accordance with this legislation. So that is the most feasible action that may be taken by Indonesia, as because ICJ has adopted such advisory opinion, then Indonesia is quote unquote in a safe place to do so, because no one would be able, well, arguably, no one would be able to argue on Indonesia's position in taking fixed baseline at that time. That is all. I'd like to thank you once again, everyone, for bearing with me until the end of my presentation time. I'll give it back to Bujo, and also for the participants if there are any questions. Thank you.
All right, thank you, Leah, for the insightful presentation. But before we move on, let me greet Professor Idewagede Palguna. Thank you for joining us, Professor. And like what Leah said before about her presentation, and also Pak Budi said previously, that when we studying law, it's also important for us to look beyond the legal aspect of what we learn. Like when we learn about law of the sea, you will find many technical things. Maybe let me remark one name that he's not from his basic not law, but he really famous in a law of the sea, Bapak Dr. Made Andi Arsana ya, and the lecturer from Geodesi UGM. So once again, thank you for Leah. Very insightful presentation. Maybe we can give Leah applause, big applause for her. So now we can move on to discussion session. So if anyone has question or comment, please feel free to raise your hand, of course, and open your mic and camera. But if you feel shy, so you can type on chat box, or maybe or if there is any comment from Bapak Dr. Imade Budi Arsika or Professor Parikesit, maybe. If Professor Palguna still here, maybe is there any comment before the questions from the participant? Okay. So for participants, for your questions or comments, you may open your mic, open your camera. Okay, for Naya.
Good evening, Bu Cok, Prof. Sigit, Pak Budi, and Kak Lea. Before I ask the question, I want to appreciate Kak Lea for the insightful presentation today. And well, my question is a bit foreseen question, I guess. So in the future, let's say in the future international conference, the ambulatory baseline approach wins because major maritime nations dominate the negotiations to protect their own interests. So, Kak Lea, especially in your opinion, what is the absolute worst case scenario for low-lying island states like Tuvalu and the Maldives? And turning to our national context, since Indonesia also has the 1945 constitutions of the Republic of Indonesia as its supreme law, which strictly mandates the protection of our archipelagic sovereignty under the Article 25A. How catastrophic would this outcome be for Indonesia's maritime boundaries and constitutional interests? I think that's all from me. Thank you.
Okay, for Leah, maybe you will directly answer Naya's question? Or you
Yes.
still need your time?
I think I'll just directly answer. Well, maybe if the other participants have any questions, they may formulate their questions or just send it in the chat. Before that, Naya, may I confirm if like the catastrophic effect being questioned was if Indonesia applied fixed basin or if it is not?
If Indonesia, sorry, can you repeat your question?
What do you mean that by having whether it has catastrophic effect is if Indonesia applies fixed baseline or if Indonesia doesn't apply fixed baseline? By
Or
what you meant?
if Indonesia doesn't apply the fixed baseline.
Okay. All right. So if Indonesia decides to not apply fixed basin and if it still applies ambulatory basin. So what I take from the question is, what if in the future there is a conference, right? And then all of the states agreed that, okay, so baseline shall be considered as ambulatory. Any baseline shall be determined by the physical reality. For Indonesia, first, the practical catastrophic effect. Personally, I think that for Indonesia, it would not be like quote unquote catastrophic, while for some other states, such as Tuvalu, in which I've shown how even the minister like gave a public speech over the risk of them losing their territory, that would be catastrophic because if there are no safeguards through, let's say, fixed baseline for them to legally maintain their rights over their territory. If the sea level rise has caused such an effect where states like Tuvalu lost their territory as a whole, that would be catastrophic because then the question on the legality and the recognition over um, the existence of the state itself would be questionable in international and by the international community. For Indonesia, as much as I know, Indonesia is not really at a risk of losing their territory as a whole, whilst for some part it does. Like let's say Jakarta, if I'm not wrong, some part of it are actually already below the the level of the ocean, and if there are no practical measure on that, Jakarta might be like gone in the face of climate change. Also similar with Bali. If I'm not wrong, Bali is also like some parts of it, other than the high-lying areas, um, they are also at risk of losing their territory if the climate change goes on and on until some parts of the state or even all parts of the state submerged completely in the sea. So, by that saying, the catastrophic or just basically the negative effect on Indonesia would be Indonesia would lose their rights onto parts of their EEZ, onto parts of their territorial sea, where they could have um, used the maritime resources over there. Because if, um, wait, I'll just go back to this part. So by this illustration, if Indonesia has established their baseline through method of fixed baseline, they would have right over this part, the additional part where the EEZ was quote unquote kind of extended and the territorial sea also are extended by the fixed baseline method. But if Indonesia were to rely on the actual coastline, then they would lose this part. While perhaps there are certain economic value of the maritime resources in these additional areas. So yeah, basically, what has been also reported on medias, on news and medias, Indonesia has currently already lost. I'm not sure like how many percentages of their maritime resources that are lost because of climate change, but exactly because they have lost the rights on certain parts of the sea where because of climate change they cannot rely on the EEZ that was already established at a certain point and at a certain time, then the effect on Indonesia would be first economical and also second in terms of territory if there are submerged territories of Indonesia in the future. In accordance with like what Naya has mentioned before, the Constitution of Indonesia, this is exactly why Indonesia supported the concept of fixed baseline because through fixed baseline, it supported the idea of permanent sovereignty over natural resources even further. So this is what I refer to, the permanent sovereignty over natural resources. While the previous concept of permanent sovereignty would only rely on the actual geographical of the state, through fixed baseline, it would extend the rights of a state yet again on the maritime resources that they have. And hence why the concept of fixed basin would be the most beneficial for the state in terms of practicality and also in accordance with the constitution, that because of such method, Indonesia may retain their rights over resources that might have been lost if the climate change and the sea level rise keep continuing over the time. So yeah, that's all for the answer. Would it suffice for now?
Okay, thank you, Leah, for the answers from Naya's questions. Any other participants questions? You may raise your hand and open your mic. Okay, from our sorry, I forgot to ini. Thank you for Pasha, our beloved MC. You may open your mic and ask question to Kakak Lea.
Okay, thank you for Bu Dia, and thank you for Kak Lea for the insights. So regarding this fixed baseline issues, I have a questions concerning the current disputes in South China Sea that was centered on the Spratly Islands. So as we know, the disputed reef in the South China Sea is very low elevated, like it's only a small island and even a reef that it's like it's not exceed 10 meter or more. It's like if the sea level continue to increase, I think there will be underwater just in no time. So my question, if a disputed reef in the South China Sea permanently sinks due to the sea levels permanently sinks due to sea level rise, should the occupied maritime claim become null and void because the land has disappeared, or should it remain legally locked in place forever according to the fixed baseline rule?
Okay, so Leah, do you want to directly answer the question?
Yes, I will directly answer the question. So, Pasha, is this South China Sea is the same with the South China Sea arbitration case where there is the 10-9 or 10 dash line? Are you referring to the same case? Okay. So, then before answering to the possibility of in the future if the like Reaper Island is completely submerged, then first on the 9 dash or 10 dash line currently, um, has also talked about this on the previous sessions of international law today. And as much as I'm not researching very deeply on that matter, it is an issue that must be first addressed before we go to that possibility, right? So, on that 9 or 10 dash line, first of all, it is a blatant violation of international law. There is um, no basis in UNCLOS nor in customary international, and I think it has also been stated by the arbitration, if I'm not wrong, and also as called upon by the international community. So that is first. However, if China and the relevant states uh, are then not applying the 9 or 10 dash line, then they would refer to the basic concept of having EEZ in accordance with the baseline, right? Now we will get onto the point on the hypothetical question if the relevant island is submerged. This is where fixed baseline comes to play. So if the states in their maritime delimitation has determined a certain base points and the certain base points are put in that island, then actually even if there's no question of fixed baseline, if you check on Article 62 of the Vienna Convention on the Law of Treaties about subsequent changes. Wait, I'm so sorry. I'm not sure about like the title of the articles, but it talks about the possibility of the termination of a treaty or withdrawal or any actions relating to the treaty if there are changes on to the object or the circumstances surrounding the treaty. And in that article, it is stated that such subsequent changes, fundamental changes, if I'm not wrong, fundamental changes to the circumstances of the treaty may be a valid basis of a termination or a withdrawal of a treaty, except on treaties concerning territories. So, even if we put aside the questions on fixed baseline, if there are already a maritime delimitation agreement between China and the other states, which puts the relevant base points on that island, notwithstanding the subsequent changes on that island, be it exist or be it submerged completely underwater, the determined lines will still be in accordance with what they have agreed before on the delimitation agreement. Except if, of course, if any states are to submit a dispute relating to that because of the subsequent changes, but it is not automatic. That is first. And what if the relevant states, submitted a dispute onto the court, be it EEZs, ICJ, or arbitration, relating to the maritime delimitation after the island has completely submerged? Then, as stated here, okay, then as stated here, and this is also why fixed basin is stated to be redundant, at the time of the dispute, then the court will have no other choice than to rely on the physical reality of the relevant states, on the relevant coastlines. So at that time, then the court nor the states may rely on the already agreed upon or on the already published coordinates of the fixed baseline anymore, as the court would then establish the base points that relies on the physical geography at that time where the island has already submerged. So a little bit of like a red lining of this answer is that fixed baseline would only be effective if it is not faced with any disputes. If fixed baseline is not disputed by any relevant countries of a state, then it would be valid. However, if the application of fixed baseline is then disputed to the court, then it will be a problem because the court will establish the actual base points according to the physical reality. So that's all. Pasha, would there be any like follow-up questions?
I think that's all, Kak. Thank you.
Okay, thank you, Pasha, and thank you, Leah. Any other question from participants? You may directly open your mic. Okay, from our Lanina.
Okay, thank you so much. I really appreciate this insightful session with Kak Lea. I just wanted to ask a really simple question. What would you prefer more, fixed baseline or an ambulatory one for a more sustainable international law?
Okay, Leah, you may directly answer the question. I think you
Thank
can
you.
directly answer the question.
Yes. I think that the answer would be really opinion based, right? And if you were to ask my opinion, then I would really prefer fixed baseline because that way states may retain their right to their maritime resources. However, fixed baseline, as I've mentioned also in the conclusion part of my thesis, I stated that, well, for Indonesia, it is the best approach for Indonesia's government to apply and clearly state their intention to apply fixed baseline. However, case by case basis still, because while Indonesia has established maritime delimitation agreement with like Australia and some other states that are the neighboring countries. There are also certain neighboring countries where Indonesia has not established a maritime delimitation with. First, Timor-Leste, and for Timor-Leste, as far as I'm aware of, um, at the time of the succession of Timor-Leste from Indonesia, the government of Indonesia and Timor-Leste has agreed upon a territorial agreement. So only territorial, but it doesn't apply for EEZ and all of the other things. So the right to EEZ of Indonesia and Timor-Leste are still in accordance with the territorial agreement at that time. And this is why I would say case by case basis still, because for Indonesia, it is a state that is surrounded by other neighboring states. There, as far as I'm aware of, there are no part of Indonesia that are immediately open to the what do I say? To the ocean without being closed off by neighboring countries. And that is why, even if Indonesia were to apply fixed baseline, in cases for Indonesia's future negotiations with neighboring countries, it must still act to reach a conclusion of the negotiation that is equitable for both Indonesia and the other countries. Indonesia cannot act just by their own national interests, but they must negotiate in accordance with the others' national interests to reach an equitable result. Because back again, Indonesia has a very long history in the development of international law, starting from Prof. Mohtar. Prof. Mohtar is a very renowned figure in Indonesian history, and Indonesia has made a very good image in international diplomatic relations in terms of the development of the law of the sea, even though there are certain questionable acts taken by Indonesia on the last few years, but still Indonesia must act in accordance with the rashly saying Indonesia must jaga image. Indonesia must act in accordance with how such very prominent state in the development of the law of the sea would do. So that's all from me. Thank you.
Okay, thank you, Lanina. Thank you, Leah. We still have about 15 minutes to 20 minutes time left. So any other question from participants? Maybe any other questions? You may open your mic. Questions, comment? I'm one of examiner for when Leah has her last
Examination.
Okay. Pak Budi, maybe there is comment for Leah or Prof. Parikesit?
Well, thank you, Ibu Dr. Chodia. I think I learned from what Leah explained. Yeah, Leah, could you just let's say back to the previous slides about when you explain about EEZ? That one. Yeah, that one. I was interested in this issue when you explained that and changed the the line. Just I would like to know about the, let's say, in which part of Indonesian maritime boundary, this problem occurs. Let's say whether in the boundary between Indonesia and Malaysia, or between Indonesia and perhaps Australia, or maybe in with the Singapore, or some parts with the Timor-Leste, perhaps. Please, Leah.
Alright, thank you, Pak Budi. So, the question is, where would there occurs a problem, especially if Indonesia applies fixed baseline? I would say that it would add certain considerations for states to which Indonesia has not agreed upon a maritime delimitation with. Because if Indonesia has agreed upon a maritime delimitation agreement with a certain state, let's say if Indonesia, and as far as I remember, Indonesia did already agree upon a maritime delimitation agreement with Australia, then whether Indonesia applies fixed baseline
Moment,
or
please.
not.
Sorry, Leah, your voice, please.
Oh, okay.
That's better.
Sorry. Okay. So, the simplest question, the simplest answer would be, if Indonesia were to apply fixed baseline, it would add considerations on the future maritime delimitation agreement that Indonesia would take. So for those states where Indonesia has already established a maritime delimitation agreement with, such as with Australia, the application of fixed baseline would not really be relevant, because the determination of the maritime delimitation of their EEZ and also their continental shelf would already be set in stone in the international agreement that they have agreed with. However, for those upcoming uh, maritime delimitation agreement, which are currently still on negotiations, such as with Timor-Leste and also Papua New Guinea, it would be possibly an addition to the consideration on whether at that time where Indonesia and those states are to um, agree upon a maritime delimitation of their EEZ, whether Indonesia wants to refer to the actual baseline at that time, or by the fixed baseline that has been delineated in their, sorry, that has been delineated in their PP nomor 37 tahun 2008. So this would then be just this would be again where Indonesia must take a consideration on a case by case basis, because Indonesia must consider the national interest of its country and also find the middle ground with the other states, such as Timor-Leste and Papua New Guinea, which are currently still in the process of negotiating the maritime delimitation between those states. So that's all from me, Pak Budi.
Thank you very much. Thank you very much, Ms. Leah and Ibu Dr. Chonya.
Thank you for Pak Budi and also for Leah. If I'm not mistaken, this case that brought you to the DC, is it right? Am I right? Okay. Am I right? So this about fixed baseline has history and good good memory for Universitas Udayana, yes, Prof, for Faculty of Law,
Yes,
Universitas Udayana.
that's
And
true.
yes, for 2027, not in DC anymore, but international round will held in Toronto. They moved to Toronto for the first time. So is there any comment or question for the time left? The last one, maybe? Okay, so if there is no comment, there is no question. So once again, thank you very much for Leah for very insightful presentation, and thank you for being part of SYL. We got a lot of beautiful memories. Thank you very much. Okay, before we conclude today's session, I would like to sincerely thank you everyone for your active participation, insightful question, and valuable contributions to our discussion. Today's discussion has highlighted the climate change presents significant challenge to the existing framework of maritime boundaries, particularly concerning fixed baselines. The ICJ advisory opinion and Indonesia's territorial jurisdiction. These issues demonstrate the need for continuous development of international law to address emerging global challenges while ensuring legal certainty and fairness for all states. I hope today's discussions has provided a deeper understanding of this important topic and inspired further research and dialogue in the field of international law. Finally, I would like to express my sincere appreciation to our speaker for the excellent presentation and to all participants for your time and engagement. Thank you. And once again, I wish you all wonderful day. This concludes our discussion. Good night. And my time, I give it back to our beloved MC. Thank you, Pasar.
Okay, thank you to Ibu Chodia, Miss Leah, distinguished guests, and all participants for the awesome discussion sessions. We really appreciate your dedication to make this dialogue more meaningful. Before we proceed to the closing of today's session, we kindly ask participants to fill out the final attendance link that will be shared in the chat box.
Okay. Okay.
Now, I would like to invite all participants to turn the cameras on as we begin the documentation session. To all participants, please turn on your cameras. Okay, Now, I will lead the photo sessions, starting in 1, 2, 3. And once again, 3, 2, 1. Thank you. As we conclude today's sessions, I would like to express my sincere gratitude to everyone for your valuable contribution to today's discussions. Please ensure you complete the attendance form to obtain the certificate. On behalf of the organizing committee, thank you for your active participation. We look forward to seeing you again at our future events. Om Santi Shanti Santi Om. Wassalamualaikum warahmatullahi wabarakatuh. Shalom. Nama budaya. May peace be upon us.
Matur suksema, terima kasih banyak.